All right, thank you. It's February 22nd. We have Eric Fitzpatrick here. We're going to hear a new walkthrough on the new version of S4. And I just want to make a note, the two sponsors of the bill aren't able to be here today, so this is going to be more of a higher level walkthrough. I don't think we're going to be trying to make too many changes or anything like that in this conversation, but just to get an idea of what the new provisions are, any changes that have been made.
Sure, sounds good. Thanks. You bet. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee about what's now version number 4.1. Make sure everyone has the correct version, dated today, just 15 minutes ago, so you can tell it's hot off the presses. The changes between this version and the previous version are shown in highlights, and you'll see that there aren't that many compared to the previous draft that we looked at, but I will walk the committee through what they are so we get a sense of what the differences are between 4.1 and 3.1. So turning right to the first section of the bill, remember this has to do with the transfer of juvenile cases from the family division to the criminal division. Remember, that's where the listed what is known currently in law as the Big 12 offenses are. Those are cases that, depending on the age of the child, can be transferred from the family division to the criminal division. And remember, the committee has been discussing what offenses may be appropriate to add to that Big 12 list, to expand the list to encompass other offenses that could be transferred from the family to the criminal division. And there was agreement on all the way through. You'll see up through subdivision 18, which is over on page 3. I think up until then, the committee had agreed that the several offenses to be added. And number 18, this is a particular type of offense, violation of condition of release. And the language in lines 3 through 5 is the same as you looked at in the previous version. And the idea here is that, remember, the issue was that if someone has had their case transferred from the criminal division to the family division, that could be for a youthful offender proceeding, it could be because transfer down is also permitted in certain circumstances. That, and even if the transfer had not occurred, now that I think of it, the violation of conditions of release offense is not itself a Big 12 offense. So if someone even if someone's case is in the criminal division, so it's being treated as a criminal case, maybe because it transferred up from the family division, or because it was one of the Big 12 and it started in the criminal division, for whatever reason, it's in the criminal division. If someone violates the conditions of release that the court has imposed for that case, well, that is a case that has to start in the family division because it's not in the Big 12. Everybody see that? So that creates this sort of disjointed situation where you've got a case going on in the criminal division, but a condition of release related to the same case would have to be filed in the family division. So the idea here is to say that, well, keep those matters together so that you'll see that the language of the previous draft says, all right, well, what to expand the Big 12, what offenses will get filed in the criminal division? One is a violation of the condition of release imposed by the criminal division for any of the offenses within this subsection. The idea being that if it's one of those listed offenses, it's going to be in the criminal division already. So if you do your violation of conditions of release related to one of those offenses, that shouldn't be a separate proceeding in the family division. It should be connected to the same case in the criminal division. So that's what that language does. The new highlighted language made clear that it's not just one of the Big 12 cases that would apply to. That's the first phrase. Because you might have a case sitting in the criminal division, not because it was a Big 12, but because it was transferred up from the family division. Because remember, there's that, as we looked at, there's the opportunity to have a hearing, make a motion, transfer the case up. Maybe one of those cases, and if it's in the criminal division for that reason, then you'd want the same result. You'd still want a violation of conditions of release, to be filed in the criminal division also, so the proceedings stay together, rather than having one of them going on in the family division and another one related to the same case going on in the criminal division. So that's what that second phrase means, or for any other offense that was transferred from the criminal division. And then the last clause, comma, if the proceeding is in criminal division when the violation occurs. That's just to make sure that the case is still sitting there in the criminal division when this happens. You don't want it, if the case for some reason has been transferred to the family division for youthful offender treatment or some other reason, then you don't want the violations of conditions of release charge to be happening in the criminal division. You want that to be done in the family division as well, because that's where the case went. So it's trying to keep these proceedings together rather than having them go on in two different places at the same time.
So it doesn't really change or make it easier or different to take one case from the other place. It just links the case for the same person so that wherever the sort of primary case is happening, the other one's happening alongside it.
That's exactly right.
Okay, thank you.
So that's the idea of that language, and to clarify that Big 12 expansion and what circumstances it applies. So that brings us to, now we're still in this transfer section of the bill, section 1, and this brings us over to page 6. Now this is, you'll recall last time when the committee discussed this, it is the ping pong issue that has been subject of a lot of discussions between different stakeholders and the committee as well. And remember, this idea is that because of the way in which a youthful offender proceeding has to be filed under current law, in order to get into the family division for a youthful offender proceeding, unless it's a direct file, which is a separate issue, but if it's not, the case starts in the family division, for example, a misdemeanor against a 16, 17, 18-year-old, and people think that it may be better off treated as a youthful offender proceeding, which is also in the family division. You can't just keep it in the family division and do that. You have to go up to the criminal division, has to be transferred up there, and then go back down to the family division for treatment as a youthful offender. That's what's, we've been calling the ping pong. And the idea to try and address that was to create a situation where you would permit a proceeding to remain in the family division if the youthful offender proceeding is going to be what happens next. So the parties went out to try and work on some language to come to consensus on this. They did reach what I think is a partial consensus, and that has to do with the situation where, let's say that the parties all agree that, in this case, it's been filed as a juvenile offense in the family division. Rather than transferred up to the criminal division and treat the child as in a criminal case, it really makes more sense to treat it as a youthful offender proceeding. If the parties can agree on that, that's what this language does. It says if the parties can agree, then we're going to develop a process that permits them to just stay right there in the family division. You have to go up to the criminal division and go back down, and you'll see the way it works is page 6, lines 10 to 12. What it allows the parties to do is to stipulate, to agree, to convert the juvenile proceeding to a youthful offender proceeding under Chapter 52A. So the stipulation is basically this agreement. Parties can reach consensus on that, then they can just move right ahead, and that allows the court to do that too. You see, it goes on to say if the parties do stipulate to convert this proceeding, the court may proceed immediately to a youthful offender consideration hearing. So they don't have to go up to the criminal division, go through that whole extra layer of process, the extra hearing. They can proceed right to the YO hearing. And then the last line had to do with another issue you may remember being discussed last time, which is that there's a report that the Department for Children and Families does in connection with the youthful offender proceeding to provide the court with guidance about whether this is an appropriate case. And they wanted to make sure that that report still got done, even in cases that became youthful offender cases in this manner. So that just says, all right, the court shall request that the department complete that consideration report before the court accepts the case for youthful offender treatment in this manner.
So Eric, so when we see the department, we just assume it's DCF then? Or?
Yes, elsewhere in this chapter, in the definition section, it says department, because Department for Children and Families, exactly. So I should point out here, so that is a partial agreement, I think, that the stakeholders have reached with respect to the ping pong issue. There still is, you think about it, another universe of cases in which the parties might not agree, and they might not agree that a youthful offender proceeding is appropriate. You remember the administration had a proposal on how to address that. I think Marshall had some language on how to address that, and the committee may want to think about how to approach it or allow, I understand there's, might not be a vote today, maybe allow the parties, some additional time to percolate on that, see if there might be a way to address it. So it's only a partial step, but on the other hand, it is a partial step that goes some way toward addressing the ping pong issue that I think the committee has been talking about and looking for a way to resolve. That makes sense for that piece? It does, yeah.
Thank
Sure. And as I say, there's only a few other things. Oh, okay, so this last one is not last.
There's also a change on page 7. Is that new or?
Let's see, where's the?
Are any of these new changes in this version, or you said the highlighted is the new version, right?
Exactly.
Okay, all right,
Yes.
just.
Oh, right, yeah, there's still changes to the underlying law. You're right, if it's not highlighted, it's not a change from the previous version. And the next one of those, although even sort of contradict what I just said, page 10 at the bottom, this is highlighted not because it's an actual change, but because it was still a topic that the committee was discussing. And I think hadn't quite reached resolution on yet, so I just highlighted it so we didn't forget about it. And that's the question of whether or not to add the, this is the list of prohibited persons who are prohibited from possessing a firearm. And remember, the Vermont statutes have a current list of this. This proposal is to add a few categories to parallel some federal law that also has a prohibited person statute. And I think everyone had agreed on lines 18 to 19, if the person is the subject of a RFA, final relief from abuse order, and the committee was still discussing whether or not a final order against stalking would also prohibit someone from possessing a firearm. And that was the issue in the column stalking, an order that the court can issue with respect to parties who aren't just family members or household members. So that's another one to continue thinking about.
You said both of those fall under stalking, was aggravated stalking. There's 2 separate charges for stalking versus aggravated stalking.
Yes, and the way it's phrased now, that would include aggravated
That
stalking
would
as well.
include aggravated stalking.
Yes, although, let me double check on that. I want to, it's possible now that I look at it that aggravated stalking is not 5133. You see, that's a specific cross-reference. Although now that I think of it, aggravated stalking is a criminal provision, this is a civil order. So I'll double check that for you. Make sure that it includes both. Let's see. The other is there's a minor change on page 13. You'll see this is in the grant program, the Community Violence Prevention Grant Program, and this is line 17 of page 13, I should say. And that's the application of the word nonprofit. It's the organizations that can apply for one of these grants. Previously, it just said organization, and I think that is in the direction. Chair.
That's something I wish I brought it up earlier, but I've been thinking of it much more recently. I think that's something we could talk a bit more about, because I feel like narrowing it just to nonprofits or municipality really narrows the scope as to who can submit an application. So just flag it as something that we can talk about.
Yeah, I'll keep it highlighted.
And I know that's something that Senator Sears brought up, so just want to make sure he's here when we talk about it.
Yeah, I'll keep the highlighting in so we don't lose sight of it.
Right. Anything from you guys?
Oh, we've been over and over it. Yes.
Can you recite it yet, word for word?
No.
He's getting there.
Soon.
Anything else, Eric?
No, I think that's it.
Thank you.
Sure.
We got plenty of time. So Marshall, do you want to weigh in while you're here?
Sure, and I'll weigh in specifically on, well, I'll weigh in on 2 parts. First of all, we're happy with the changes that were made on page 3 to number 18, which is bringing conditions of release in, because we think that's the appropriate way to handle it. It's actually a policy change from our office. Years ago, when this was happening, this was under discussion, and it was our opinion that because violations of conditions of release are misdemeanors, they should belong in the juvenile division when they're committed by a juvenile, regardless of where, which court imposed the conditions of release. But frankly, the practical effect of it has just been that it honestly doesn't make sense. It makes it harder to resolve cases. Usually it's easier to resolve your condition, like if you have an underlying charge and violations of conditions of release that are associated with it, they're almost always resolved together as one package. It's rare that they wind up split up. And so frankly, from our perspective, even though we started out supporting keeping VCRs in the juvenile court because of their misdemeanor nature and the very low level of punishment that's applied to them, the low penalty that's applied to them, we agree at this point that it's frankly better to just make sure that wherever the case is where the VCRs are as well. If the case begins in the criminal court and the criminal court issues conditions of release and then the case transfers to the juvenile court, then any violations of conditions of release should be in the juvenile court. And if the case remains in the criminal court, then they should be in the criminal court. That's just simply to make resolving the cases and practicing the law easier. And honestly, we would wind up in these ridiculous situations where you would have a kid who was charged with a fairly serious charge in a criminal court and was getting sentenced in the criminal court, getting an adult sentence in the criminal court, and also at the same time getting a juvenile disposition to address their violations of conditions of release, which is just sort of, it's as if you smashed an egg with a sledgehammer and then went after it, trying to put it all back together with a frying pan. These are just two different systems. They work differently. It honestly doesn't make sense to try to combine them in that way. So even though that's a policy change for us as an office, we are supportive of that language.
So with this policy change, do you feel that this will increase the efficiency and reduce the amount of time that's spent in managing these cases and the back and forth?
Yes, and it's going to reduce it across the board because it'll be less separate court processes because VCRs will, usually just be heard alongside the underlying offense. So as long as they're in the same court, it's going to increase efficiency there. It's also going to increase efficiency for attorneys. We have separate adult and juvenile division attorneys by contract and in a lot of our offices. And that means it's a continuity of counsel problem also. We feel that it's better. The ideal situation is to have one client represented by one attorney in all of their cases, and that gets really hard to do when their cases are, when they have DCRs in the juvenile court and an underlying serious criminal charge in the criminal court. It can be hard to make sure that we have the same counsel on both of those cases. So for us, it's an efficiency across the board. And I would strongly suspect, though I can't speak for anybody else, that probably all the other players in the system feel the same way because they run into all the same headaches we do, having those types of cases split up.
Thank you. Any questions?
No, that makes sense to me.
So then I'll also comment on, unless there's more questions on that. I'll also comment on page 6. This is the new ping pong language in subsection 3. And I think we're okay with that. We've been back and forth overnight in conversations with DCF and Jared Bianchi, and we proposed some language that Jared had proposed this as an alternative to, and I think that it is an acceptable alternative. I think that everybody is correct that this is a complicated problem, a ping pong problem, and that we want to make sure to get it right. And I think there was concerns about sort of potential unintended consequences in some of our earlier drafting. And so this is more limited in scope. This will not eliminate the ping pong problem. This will leave it so that we will sometimes still have a ping pong problem, but it'll take the vast majority of these cases, because in the vast majority of these cases, everybody knows where they're going. The prosecutor, the defense attorney, the defendant, everybody's aware. Like, we'll have discussions in the hallway and we'll say, this looks like a youthful offender case to me. And so in a lot of these cases, I think the majority of them will be able to reach agreement anyway. And then this provision, as Jared has written it and Eric has put it into legislative language, will allow us to deal with every single one of those cases where we can get agreement to move right to the youthful offender consideration hearing very promptly. And so I think that'll help solve that problem. And then I think the juvenile justice stakeholders group, it'll be good to have this in place and see how many of the ping pong problems this provision addresses and how many are still out there. And if we still have a ping pong problem where we have a lot of cases where we're not getting agreement among the parties, but we're still going through that process of going from juvenile to criminal to juvenile again, then the juvenile justice stakeholders group should certainly work on that over the summer and come back with some language that would address that. Because I don't think it's an unsolvable problem. It's just that juvenile law is very complicated. It's very statutory. There's not a lot of history behind it. We've been developing the criminal law for the last 650 years. So it's a more complicated area of law, and I think that if we spend time, if the stakeholders group spends time on it over the summer, they'd certainly be able to come up with something to address what I think will be the smaller category of ping pong cases that this provision won't catch. Thanks. And I don't think I had, unless you have any other specific questions for me. I don't think I had any other comments.
No, nothing specific, but thank you. And we do still have an hour left, and I know there's a number of folks on Zoom. I already see one hand up, so maybe we can spend some time hearing from some of the witnesses that we have, since we have so much time at the moment. So Jay, if you did you want to chime in?
Sorry. Yes, Senator. Thank you. Sorry, I'm a little slow on Zoom. Oh, shoot. And you can't see me because I'm standing at my desk and my camera in my, never mind. So anyway, I was just to Marshall's points, and I'm gathering Senator Sears and Senator Bruthen out there. It's I do want to thank the committee for the work that it's done to date. I think that, the progress has been great. And I wanted to thank the Defender General's office for the work that they have done and the input that Marshall just gave on that section regarding the violations of conditions of release. I think it's really important for all the parties, all the stakeholders in the justice community to be recognizing when there are efficiencies to be gained for the system in its entirety. My concern, I guess, with what Marshall just said with respect to the provision that it has been agreed with respect to the transfers and the limited ping pong, I think is that the committee, and I want Senator Sears to understand this too, but is that the committee understand that it is a very, very limited, narrow approach to the ping pong. It will have some effect. I don't know that we know what that is. I couldn't weigh in on whether it's the vast majority or the plural. I mean, I have no idea, but I would say that one thing I would really like, and to Marshall's point about the Juvenile Justice Stakeholders Group, and I don't know if they are the appropriate entity, is we did make a proposal that was pretty comprehensive in terms of addressing efficiencies in the system, which would benefit both the kids because they would have access to services in a much more streamlined time frame, and they would have the protections that they've been given in law to date. I think there is some controversy about whether the conditional plea violates the Sixth Amendment of the Constitution. And so I would say that that we would like to keep that proposal in play if possible, and if it means a study over the summer, we would fully support that. But I think that we don't want to just throw this to the juvenile. I mean, sure, it will probably go to the juvenile justice stakeholders group, but we would like some serious consideration of our proposal, because it was a very comprehensive, thought out proposal that really did try to address all of the concerns that have been raised, I think, by the defense bar. So I would appreciate the committee's consideration of that. The only other thing that I wanted to note is in section, I believe it's still section 7, with respect to while committing a felony. It's the modification to 13 VSA 4005. We had asked that the cross-reference to 18 VSA 4253 be removed, because that actually refers to use of a firearm while selling or dispensing a drug. That if the committee is not inclined to deleting that cross-reference, because there are penalties in 18 VSA 4253, I would appreciate if the committee would consider adding the language that they've added in section 7 with respect to the bail provision. So that's, 18 VSA 4253 includes a straw purchases concept. It also includes, and basically use of a firearm is not specifically defined, but is defined to include a straw purchase concept. And since you have made this bail provision applicable in the context of straw purchases and while committing a felony, I'm just asking that the committee consider that same language for 18 VSA 4253.
Thank you.
Thank you.
And just to your earlier point, Senator Sears is planning to watch the recording of this to take into consideration. What I brought up at the beginning is that, the two main sponsors of this bill aren't here today. So, we're just trying to gather as much information as we can about some of the changes, and then we'll definitely reconvene and bring these points back up. So.
Terrific. Thanks. Thanks, Senator.
Absolutely. So is there anyone else in the Zoom room who'd like to chime in, or are there any questions for Jay from you guys? Okay. Jared?
Thank you, Senator. I wanted to, first of all, just echo some of what Marshall said about the provisions concerning the transfer, but also what Attorney Pershing Johnson has said. We continue to think that the best way to realize those efficiencies and move beyond this ping pong issue is found in the administration's proposal. That said, the work continues even while we have these discussions, and much as Marshall has said, in many cases, having the option available to do things by agreement will realize at least some efficiencies for the cases where we do have agreement. And that is often the case. In our caseload, we do work closely with our partners at the Public Defender's Office. With respect to the modification on page 3, line 5, I am concerned that this language could create some confusion in a situation where a matter has been transferred up from the family division, but is pending a final determination on youthful offender. I think there's a very small technical change that could, and actually I can either read it now or send it to Eric. I'd be happy to copy the other stakeholders who are on or present in the room. But I think that there's a small technical change that would clarify that what I believe is the intent here, which is that this would not attach if a matter had otherwise left the jurisdiction of the criminal division. So, I think that a small change just indicating that the criminal division jurisdiction will continue pending a final decision on youthful offender would resolve any concerns about clarity. And I'd be happy again to either read that proposed change now or send that to Attorney Fitzpatrick.
If you could send that language along, that would be great.
Thank you.
Thank you.
Otherwise, as we said,
Or if you want to share it too, that would also be great, but also please send it along.
sure. Well, I'll read it now. I had it written down, and this is sort of, this is a new draft, so bear with me, but it currently reads 18, a violation of a condition of release as defined in 13 VSA 7559 imposed by the criminal division for any of the offenses listed in the subsection or for any other offense that was transferred from the family division pursuant to the section. And then I have new language here, which would be unless the proceeding has otherwise been the subject of a final order accepting the matter for treatment as a youthful offender pursuant to 33 VSA section 5281D. So in other words, if there's a final decision that the family division is where the case will live, we would no longer have, there would no longer be the opportunity to direct file here. But if it's not yet been accepted as a final matter for transfer to the family division, the criminal division would retain that jurisdiction. And again, I'm happy to send that language along.
Thank you, Jared.
I was just gonna say, I think that's actually, I'm not quite sure I understand Jared's language, but I think I understand what he's getting at. And I think we would probably support that because if I recall, that's consistent with language that's already in the youthful offender chapter, subchapter. And I'm trying to find it because I know we went through this when we were doing the legislation before to make sure that during the period of time, because it's a good point that Jared brought up, during the period of time where the case has been in the criminal court and conditions of release have been imposed, and then it transfers to the juvenile court for the youthful offender consideration hearing only, that the violations of conditional release conditions of release at that point would still live in the criminal division. I think that's what Jared was trying to say. I think we already have that in law somewhere in chapter 52A. I'm trying to find it right now. And I think the language he suggested would be consistent with that. And so if all the things I think turn out to be true, then I support that.
That's good. Thank you.
I mean, is the idea, Jed, that that would take place of the last clause if the proceeding is still in the criminal division?
That's right. So that new sentence would be after the comma following the word section.
Yeah.
And just for the record, here it is where it's that's consistent with section 5281, which says conditions of release in any Department of Corrections, supervision, or custody shall remain in effect until 1, the family division accepts the case for treatment as a youthful offender, 2, any conditions of release or bail are modified or vacated pursuant to the normal Title 13 modification of release or bail, or 3, the case is otherwise concluded. So that I agree. I think that suggestion just sort of ties the language in 5204 right to that youthful offender language, and that makes sense.
Thank you.
Thank you again, Senators, for your consideration.
Absolutely.
And Jared, could you send that to everyone who was on that previous email that we had?
Absolutely.
Perfect, thank you.
And Lindy, I see your hand is up.
Hi, thank you. I also want to just thank everybody for the conversation last night and today related to the language. We also support the language that has been provided related to the limited cases that you talked about, the little bit of the ping pong, addressing some of the ping pong issues. We also agree that the administration's proposal should be considered to address the broader concerns related to the YO process.
Thank you. Is there anybody else in Zoom who wants to share any thoughts? I'm not seeing anything, so you guys want to discuss further, or you're good?
I mean, I don't feel like we should discuss the bill like really in depth without any of the delete the sponsors here.
Yeah.
So I'm,
We regurgitated things.
Yeah. I agree. All right. Well, if we're good, we can conclude early and